Well, good afternoon, ladies and gentlemen. My name is Janice, founder of American Women Writers National Museum. We're so happy to have everybody here today. And particularly we have our speakers, of course, are very distinguished, but we also have a distinguished guest, one of our board members, Helen Hester Osa. And Ms. Osa has just retired as head of publications for the U.S. Copyright Office, is that right? Mm-hmm. And we're so pleased she's a member of our board of directors, so she's one of our distinguished guests in the audience today. And I want to tell you a bit about the mission of American Women Writers National Museum is to honor America's women writers, historical and contemporary. We're 3 years old. We just celebrated our 3rd anniversary. And we don't yet have a building because, of course, bricks and mortar are very, very expensive. So we meet in rented space here at the National Press Club. And the Press Club is very generous. They allow us to use this room for free. So if any of you would like to join the Press Club, certainly consider that. Sometimes people think, well, I can't be a member of the Press Club, I'm not qualified, etc. But there are a lot of categories. There are many categories of membership, so you might qualify. Consider joining the Press Club. And I have to leave a little bit early today. I have to catch a plane so that I can get in Montgomery, Alabama by tomorrow. So that's quite an achievement. So please, when I leave, don't infer anything negative about that I'm not leaving because I don't like the speakers or something like that. Obviously, the speakers are wonderful. So I'm going to introduce them now. And they're going to speak each approximately for 20 minutes, and then there's a question period. So I know that that's the reason a lot of you came, to ask questions about your personal projects and so on. So there won't be any time for questions after the first speaker. We'll go right into the second speaker, and then we'll have questions for both of them afterwards. So this morning we're welcoming Paul Williamson, who's on my right here. And Mr. Williamson worked as a trademark examining attorney for the U.S. Patent and Trademark Office. He then served as a trademark petitions and special projects attorney for the U.S. Assistant Commissioner of Trademark. He's an expert on unfair competition issues, and he's involved with international and domestic trademark prosecution and enforcement cases. His clients include computer hardware and software, semiconductor, publications, pharmaceutical, and financial service entities. Mr. Williamson holds a BA degree in aeronautical engineering from Purdue University and a JD degree from the University of Illinois School of Law. Ms. Tara Gold, who's also on my right and is a partner with Mr. Williamson in their law firm, she represents clients in domain name and copyright disputes, advertising and consumer protection issues, as well as drafting and negotiating licensing agreements and intellectual property aspects of corporate transactions. Her expertise, oh, you don't have to leave.
Oh, I was going to say lunch.
Oh, yes, oh, sorry. Never interrupt anyone going to lunch or Ms. Bald's expertise also includes registration and enforcement of copyrights and endorsements and publicity rights. She received a BA degree cum laude from Dartmouth College and a JD degree from Northwestern University School of Law. And I might add that both of these very distinguished attorneys are cross experts. They're experts, even though I've introduced them as trademark or copyright, their expertise crosses both lines. And I want to take this opportunity to particularly thank Mr. Williamson publicly and on video. He and a team of lawyers from a law firm named Fulbright and Jaworski, where he was working at that time, are responsible for all the legal paperwork in setting up American Women Writers National Museum. They did it all for free. They did it as part of their pro bono obligation as lawyers. And so I've never had an opportunity to publicly thank Mr. Williamson. And so we really, really appreciate that. Autumn also has what's called the 50 State Project. We started that 3 years ago. Every month we honor women writers from the 4 states in alphabetical order. If you look at our website, there are videos of all 50 states where people, I see someone has seen them, they're really wonderful, where people read excerpts from the writings of women in that state. And this month we're honoring South Carolina, South Dakota, Tennessee, and Texas. So without further ado, I will give us our first speaker, Paul Williamson. Please give him a warm welcome.
Well, thank you, Judge Law. You're always too kind. And I have to say that it always makes me a little bit uncomfortable when people refer you as an expert. The expectations go way high. We have a lot of years of experience and a lot of gray hair. That counts for. Before I get started, and I'm going to talk about trademarks and basics at a few points, and I'm happy to be interrupted with questions, and we'll be around afterwards for as long as anybody has questions to ask. And I've got a sense, as you're coming in, those of you that I got to meet, how many of you are writers? Interesting, okay. And how many of you have businesses that you either own or you control? Okay. How many of you own a copyright? Almost all of us. And how many of you own a trademark? I was waiting to see if you. Well, in your seats you've got a PowerPoint set that kind of runs through the basics, and I'm going to try to avoid reading any of that to you, but just to make some comments about these slides, generally in the order that they appear. And the first page of that asks, what is intellectual property? And I'd like to tell you that I know exactly what that means, how it came to be the designation for a grouping and now an expanding group of specialties. Historically, and initially, it related to patents, trademark, copyrights, and trade secrets. Today, and those are all very different things. I want everybody to keep that in mind. They're all very different. A copyright is not a trademark. A patent is not a trademark. And I say this because I'm sure a lot of you are familiar with the issues that are going on with the Washington Redskins in their name. And I can't tell you how many times I've heard on the media, radio primarily, but I've actually seen it on television and print, referring to the Redskins losing their patent on the Washington Redskins name or the Redskins name. And it just makes me bristle. So, when we get done today, I hope we will keep these things straight, these part of the areas. But intellectual property today probably includes internet law, social media law, domain name law. It certainly includes things like show how and know how for businesses in connection with transfers of assets, etc. And I'm sure that there's other areas that I'm not mentioning. So it's kind of a morphing concept. And I couldn't begin to tell you its expanse or why it got labeled intellectual property. It's kind of an arrogant title. Anyway, I do want to say just a couple things about these areas, and starting with a patent, and the slide gives you some background. One thing I want you to know is that it's expensive property. It is a time-consuming. It takes a long time to get a patent. And once you get it, what it does for you is it's a ticket to get into the courthouse, so that you can either prosecute an infringement action or defend an action. It takes a lot of money to use the patent system. It's an important part of our system, but largely now it's getting to be an area that's for big business. It's very tough for the small men in today's world. But anyway, the last thing I will leave you before I leave this page is you never associate the patent with a trademark. They're entirely different. Trade secret, it's fairly self-explanatory. It's material that's used in a trade and a commercial business, and it's secret. It has to be kept secret. Yes, sir.
Would that be the Colonel Sanders recipe? Is that a trade secret?
Yes, as far as I know, it is maintained, and the Coca-Cola has maintained its recipe under lock and key for almost a century, I think now. So yes, it functions that way. And its viability in terms of being able to protect it depends on secrecy or the steps taken to keep it secrecy. Keep it secret. What is a copyright? You know, Tara will go into this, so I'm not going to spend any time on it, other than to say it's not a trademark. It doesn't apply to the trademark law. And it relates to expressions once they're reduced into some kind of a tangible medium. And hopefully all you writers know that, or you'll know it when you leave today. Now to the trademark side of it. The statute says that a trademark is a word, name, symbol, or device used in connection or used to indicate the source of a product or service of the owner. That's very important. Trademarks don't exist absent a particular product, a particular business, a particular service. They have to be connected. Now that definition, I think the first three, a word, name, or symbol, fairly obvious in terms of what they can, logos and made-up words and names of people, essentially. It's the device part that is really, that's the open-ended part of this practice. And in the recent decade, really, what is recognized as a registrable and a protectable trademark is expanded to include things like sound, although sound is one that's been around quite a while, going back to RCA, a couple of generations, 3 generations.
What's an example? The NBC chime?
The NBC chime.
Oh,
If you're familiar with the Intel ads, and they have there's a 5-note jingle, if you will, usually when they put up the Intel inside. That's a registered mark.
Okay.
It can include, though, taste. It can include sounds like, well, Harvey Davidson tried to protect the sound of starting motorcycle. I don't know if they ever actually got the registration. It can include touch, feel. There is a registration that I know that exists for a certain wine that has a texture on the label that certainly we regret, and that's been registered as a mark. It can include what we call trade dress or the get-up, such as you go into an Apple store or you go into a lot of restaurants and every one is set up the same way. That, if you will, that aura can function as a source, an indication of source of the product and services. Yes, ma'am.
Do they actually register that so that no one else can use, like the way Microsoft has their stuff on each wall and it's showing their products? Or can other people do that as long as it doesn't look like Microsoft?
Well, again, trade dress.
And of course, how you define.
Yeah. If a party uses a get-up, a makeup, and we're not talking about the words Microsoft, clearly that's protected.
Yeah, I'm just
But
thinking
even
what their
though-
store looks like.
Yes, if they're consistent, if they promote it, and if they can give evidence that consumers associate that particular get-up or that particular ambiance with one source, then it's a registrable device. So yes, they can protect it and stop others from using it.
But it has to be registered.
No.
Oh,
It's
it's the same, so it's the same as copyright. Once you put it on paper, it's copyrighted. The trade dress would be, once you implement it, it's there.
Yep.
Okay.
In the trademark law, you get your rights come from use, and I'd like to say proper use, and I'll explain that in just a second. And registration, but you never have to register.
Okay.
People do, and you should, just from the standpoint of the evidentiary benefits that it provides you, as well as some other practical benefits. And I've listed some of those here in the slide in terms of federal registration. But it is use-based, and that way it is like a copyright. And unlike a patent, where you don't have any rights until the government actually gives you that patent document. Another thing about trademarks, and I'm sure you all have seen the the reference trademark and then service mark maybe, or you see the TM used against next to words, or an SM. Means the same thing. And those are insignias that anyone can use. You don't have to, there's no regulations that govern the use of a TM or an SM in connection with your marks. That's really just an indication that you can choose to make if you consider this to be a mark. The difference comes when you have the R in the circle that you see all the time, like the first front page of the program up there in the upper left-hand corner. That you can only use once you have a registration, an issued registration. And we're talking about the United States right now. Trademarks are territorial, and the rights that you can establish in the United States, whether they be just based on use or supported additionally by registration, have no bearing in France or in Canada. Each country controls what constitutes a mark, and a lot of the things that the U.S. recognizes aren't recognized in other jurisdictions. But you have to keep that in mind, and that's a tough thing for a lot of owners, because of the way, most business today has an extraterritorial effect, even if they're not global. You're doing business in multiple places. You've got to, in terms of protecting a brand, you've got to be aware of and take the steps that are called for by the particular country. I mentioned, I'd like to say, use gives you rights, but it really is proper use. Remember from this that a trademark is an adjective, and there should always be a noun that follows the adjective. And whether, you may get to a point where the noun, your mark will become so strong, the adjective, people fill in the noun right behind it. So you can get away with it. But in your primary use of a trademark, any owner, the goal is to have a noun that describes or identifies what the product is or the service is. So we talk about a Ford automobile, a Google search engine, a Microsoft software. That's the proper use. You also want to be using your mark in a way that distinguishes it graphically. Whether you show it an initial cap, all caps, you use the TM that follows it when you start. You put it in italics, you give it a different color. Any of those things will help establish the particular designation in the minds of consumers as an indication of origin. And that's what you want. And I think that out of that, not only do you want to use your mark correctly, you always want to respect third-party marks in terms of using them properly. And that comes up from the sense that, and we'll get to just a little bit, I'll call it spectrum of distinctiveness of brands, different kinds of marks in order of strength. If you don't use the mark properly, you risk that it will ultimately become a generic designation, that the consumer, that the relevant consumer population will visit on that term. Now is the common name of the product. This is a battle, for example, that Kimberly-Clark fights with Kleenex, that the Xerox Corporation fights with Xerox.
Still fighting?
Still fighting. They spend money every year, and they do this intentionally from the standpoint if anyone challenges whether their mark has become generic, that they can show the steps that they've taken. They can show a judge or a jury to educate consumers. And so you'll see these ads on a regular basis from these organizations.
So instead of saying tissue, Kleenex, is that what you mean?
Yeah, it's facial tissue.
Yeah, and it can have unintended results. One of the marks that we worked on that had generic
If you speak, stand up, my
Oh,
apologies,
sure.
the videographer.
Sure.
Can pick up only above.
Generic problems can come in places where you wouldn't suspect them. One of the brands we worked on was Best Buy, and we had to, at great expense, fight an early decision on genericness. Well, Best Buy is one of the stronger marks, in American business. But steps, had to be taken to ameliorate past actions. So it's not always so obvious that you might face the issues.
But Best Buy, I'm confused. Another store might say, we have better deals. You can get a Best Buy here. Is that what you mean?
Well, our argument was the case was wrongly decided. That the genericness term was used incorrectly by the judge. Usually the genericness refers to the object itself. And in this case, they found that Best Buy was so widely used, maybe descriptive, but certainly not generic.
And this goes to federal court?
Yeah, that's right. This was a federal court decision.
Okay.
So, but
Could a book be considered an object in terms of trademark instead of copyright?
It could, under
terms
certain
of structure.
circumstances. But, and there are some points of this to the back of the handout. The Trademark Office, for many years, and this has been affirmed by the courts, including the Federal Circuit here in Washington, that a single book title cannot be registered or protected as a mark. And the idea was, and I'm not sure that this reasoning is all that sound, that one, as the name of the book, it describes, as the title of the book, it describes the contents. It may not describe it in terms of what the theme is, or whatever, but it becomes, it is connected. There's also an argument made that, because that book is subject to copyright law, and that the copyright law, in terms of covering that entire book, would include the title, even though the title itself may not be protectable through the copyright law. The office regards it as a single work, not protectable. Now, there's a decision that's not precedential at this point that just came out this last November that may change that. And if a single book is opposed to a series of books, that's a different animal. A single book may be, if you can show that it's acquired what we call a secondary meaning or a distinctiveness on the public, and they view that title
As a service.
as a mark
Yeah.
for the product. They can do it. Yes.
So you're saying somebody else could write The Grapes of Wrath and have a totally different book with the same title without violating anything, copyright or trademark? Was that?
Yeah, no, I'm not going that far because there are other parts of the law. Unfair
Oh, okay.
competition, for
Okay.
example, would be a mechanism to address that.
Okay.
So, Nora Roberts may not own something or another in death, but the little emblem she's carefully put on some of her books to indicate, this is the first time it's been printed, folks, she may have trademarked that.
She may have trademark rights. That's correct.
Okay,
Yeah.
to prevent unnamed publisher from putting that mark on their books when they reprint her books.
Well,
And I put in all the 50 million qualifiers because I don't have a clue.
well, yeah. Again, yes. If there's going to be two factors. One, that the designation on the book, whether it's a little insignia, whether it's a character, whether it's the title, whether it's the author's name. If consumers, if it's promoted in a way, if it's used in a way on the right, and this applies also to a single musical release, an album, a CD, the same theories apply. You have to be able to show, one, that the public regards it as a mark, an indication of origin, and two, that it's used in the manner of a mark. So, there are always conditions, but it's possible.
So what is the time frame for establishing what you said, quote, meaning?
Secondary meaning?
Yes.
Yes. Well, that's going to vary. Now, the Trademark Act has a Section 2F that says prima facie evidence of distinctiveness, secondary meaning,
Yes.
would be 5 years of substantially exclusive and continuous use of the designation to identify the source, the origin of the product.
Does that relate also to intellectual property in terms of internet law, as you said in the beginning, there's some trademark relationship between?
Well, there are, but this particular concept really relates primarily to marks. It also would apply, though, and things that can be encompassed. It'll apply to trade dress, it could apply to company names, it could apply to individual names. I don't know that there is anything that would be outside of that umbrella of trademark experience in the internet law that has a concept like acquired distinctness or secondary meaning. Yes, ma'am?
Is the distinction between trademark and trade dress anywhere in this information that you gave handed out today?
It is not in depth in there.
Okay,
no.
that's fine, even if
No,
it's
referenced.
Okay,
And I think the example given in there is the Apple store.
okay,
which
good.
is right.
One more thing, the thing with Mickey Mouse and Disney World and this 100-year type thing, is that trademark, trade dress, copyright? What is that?
Maybe all of the above.
All of the above. Just that is definitely a lawyer's answer. Definitely a lawyer's answer.
Well, I'd like it to be first and foremost a trademark issue, because that is one that maybe I can deal with. But it does encompass a lot of different potential rights there.
Because it's just so odd that they can like keep it forever in perpetuity.
That's the benefit, the advantage of trademark law. It is forever if you continue to use the mark properly.
Wow.
The registration can be forever. You have to renew it every 10 years. You have to show the office that you're still using it for the products that you registered it for.
And it has to be the correct use.
That's right.
Ongoing correct use.
Yep. But it can last forever.
You said it's better enforceable in terms of infringement, however, it's very expensive. What expensive?
Well, when I say
Takes a
expensive,
long
and I think, hopefully I didn't use that connection with the trademark process, because I was talking about the patent process. In the trademark area, it is not really that expensive. And to be honest, and I don't want any of you to run off and do this, you can do it yourself in terms of getting a registration. Just like with the copyright, and Tara will talk about that, the office has made it very easy with the resources that they provide consumers, writers, authors. You can do it. We have a lot of clients that will come to us and they'll have us do the first one, kind of give them a lead, and then they'll do them themselves in-house on the copyright side. The trademark side, you can do the same thing, but there are more issues depending on the nature of the mark that an experienced trademark lawyer can help you shorten the process and get it through. But you don't need a lawyer to do it.
So
You just have your filing fee.
patent, but only patent lawyers can do the trademark, or any lawyer?
No. Again, patent lawyers do patent law. They think they do. They think they know trademark law. I really shouldn't think this. I shouldn't know if it's being recorded.
I just remember right out of law school when they were like, oh, if you want to be a patent lawyer, you know you have to do extra training, and so I just remembered that, you know, they were up there and the rest of us were, you know.
Yeah, well, that's right. And most, even in my own firm though, in my early years, the patent lawyers always felt like they were a rung above.
I told you that, of course, and it's still go, yeah, okay.
But it's not true.
Okay.
So,
That's a debate for another day.
Okay, exactly. I'll keep that in mind, though.
That's right.
I'll hold my head up higher.
One thing I did want to get to, just this idea of a spectrum on marks. There are what we call fanciful or arbitrary marks. Fanciful marks being ones that are made up. Exxon would be an example. Xerox, yeah, it actually came from the word xerography, but it was made up. It's not a word in the English language. Arbitrary is a word like Apple for computers. There's no connection there, so it's an arbitrary term. Arbitrary and fanciful terms are the strongest marks. Marketing people aren't as crazy about them because it costs a lot more money when you introduce a product to have to get the consumer association to know, that it's Apple computer. The second level are suggestive marks, and they give you some sense of maybe the product or the product use, and copper tone would be an example of that for lotion. 7-Eleven for grocery store, whatnot. Burger King, suggestive. Those are a little, you know, they face arguments of descriptiveness sometimes, which is the third level. A mark that actually describes the product, a characteristic of the product, a feature, an ingredient. Those initially, the law does not regard as protectable. Now you can begin establishing rights through your use of a descriptive term, and I have some examples: chapstick, Raisin Bran, Ford, and I put Ford in there only because it's a surname. You don't think of it as descriptive, but surnames get treated just like descriptive terms under the Trademark Law. And so those require a certain amount of use, time of use, or efforts at marketing and sales, advertising to make the association that this is an identifier of a single source for this product, and that you can rely upon the quality of the product based on this mark that you find on it. Proving acquired distinctiveness or secondary meaning, can be expensive. Sometimes it's not. Just depends kind of how really descriptive was the mark and how long has it been in use. There are things that can happen that will make it an easier process. On the spectrum, then generic is at the bottom, and a term that's generic, you couldn't use pencil for any kind of a writing instrument. You couldn't use automobile or car as your brand for a car. It is the name of the product or the name of the service. It's generic and it's not registrable or protectable. There's always an exception in some place, but that's for another day too. Your questions have allowed me to cover a lot of these pages already. Thank you. The Patent and Trademark Office has two registers, the principal register and the supplemental register. And I just throw this out because the supplemental register is for marks that the office determines are not yet, they don't have an acquired distinctiveness at this point, but they are capable of, and this could be the surname. You can get a registration, what they call a supplemental registration. Sometimes it makes getting the principal registration down the road, 5 years, 10 years, much easier. I said earlier that the statute says 5 years of substantially exclusive and continuous use is prima facie evidence of acquired distinctness. The statute reads may, and the office won't accept 5 years anymore. It's more in the 10-year range or more. Or you have to show millions of dollars in advertising and promotional activity or sales with the mark, such that it's circumstantial evidence that the consumers would recognize the mark as a brand.
Do you have an example for that?
Yeah.
For
Well, anything that you just said, what you just spoke on, the 5-year or the 10-year thing. Just because I'm a little. Examples help me clarify things.
I don't know for a couple of marks that we had listed here whether they were like chapstick or Raisin Bran.
Well, Ford is the one that's confusing. The Raisin Bran and the chapstick is, I get. But the Ford...
Ford is a surname, and the statute has a section that says that the surnames are not registrable absent an acquired distinctiveness.
So by surname, you mean like Ford car. Like
Well,
when you say Ford, everyone
yes.
will immediately, your mind will go to a car.
But here's the exception.
Okay.
If a term like Ford or Bird, for example, if that was the surname, the last name, it has another meaning. And that's an exception. And in some cases, I won't say unanimously, but in some cases, you can avoid the surname rejection and you can get registration on the principal.
Well, I get it on
has
the
two
Bird,
meanings.
but Ford, I only think of
Ford and
car.
Bird. Well, that's because it's so strong as a
Right,
mark.
right.
Sorry? Oh, Rigby Books? Yeah, that was some kind of...
But
Yeah,
okay,
yeah,
that's an
right.
example,
Yeah.
maybe you've not heard of Rigby Books.
Right, right, I
That was
haven't.
the surname, you got rejected.
Got
because
it.
it hadn't been, it may have been used
Oh, I
5
see what
years,
you're
but it
saying.
hadn't.
Got it. Okay.
So
And
that-
Ford has been around so long
That's
that
right.
your mic got it.
That's right.
Okay.
It's
Thank
probably,
you.
Ford is
Sure.
almost a famous
Got
mark.
to go out there.
And of course, Dodge is now using it. They started with Ford and then to try to say, we're really a family.
Well, I've actually gone way past the time that I was supposed to be allotted. I'll be here for questions, but I want Tara to spend time on
Well, thank
the
you.
copyright side. And there may be things in there that will trigger questions, and the last 4 slides really relate to issues for writers and artists. Okay, Tara?
So we'll cover the entire world of copyright and all its nuances in the next 20 minutes. Not at all. You know, as our world goes more and more online, copyright is becoming an increasingly important issue. You know, not only have we experienced an enormous increase in the amount of copyrightable content. I don't need to tell Helen that, who works with the Copyright Office. But you know, at the same time, the Internet's created an environment where the access, copying, and distribution of that content is done with such relative ease. You know, add to that the very different nature of the copyright owners. You know, we've talked about Disney. Think about Disney's earning pressures on the copyrights versus a research institution's priority on open access. You have very different interests that you're trying to align here with the law. And you know, you're left with a very complicated situation, which is one that the Copyright Office has to deal with every day. But to fully kind of appreciate where we are now, you probably should start at the beginning. And at the beginning is the basis of copyright. Copyright, like patents, but unlike trademarks, finds its basis in both the Constitution and statutory law. So here, you know, second page of the handouts, we have the section of the Constitution, and from the very beginning, we see the founding fathers really put a primacy on the need to provide exclusive rights to authors for a limited period of time, while for this dual purpose of promoting creativity and learning generally. So, you know, that's where we start with copyrights. What is a copyright? As Paul mentioned, it's an original work of ownership, fixed in a tangible medium. And when we say fixed in a tangible medium, we mean print, software code, maybe a physical structure, a performance. That's a tangible medium, with a modicum of creativity. We talked earlier, you know, everybody knows facts and ideas are not copyrightable, right? We have slogans, titles, short phrases. Are they copyrightable? Probably not. You really have to make some pretty convincing arguments to get around that one. We try to do it all the time. And then, you know, ads, web pages, photos, reports, architecture. Sure, they're coming closer. Most of those, you know, depending upon how detailed they are, you know, you probably get to the level of copyright. You know, different forms of copyright. It sounds like most of you have been on the copyright website, so you know that there's audiovisual works like TV media, online, sound recordings, written works like lectures, articles, and books, visual works, video games and computer software, which is, you know, by far the largest growing component, and dramatic works. You know, and Paul touched on this, but you know, there are very distinct elements of IP law, but the same asset can be protected by both a trademark and a copyright. And I think this does lead to some confusion for people who are not doing this every day. But for example, the wine bottle that Paul brought up, with the texture on the wine bottle, you know, that might be protected by copyright. Certainly the winery's name might be protected by, I'm sorry, trademark. The winery's name might be protected trademark. But if the shape of the bottle is creative enough and unique enough, you might be able to get a copyright on the bottle itself and a trade dress on the bottle itself, because people see the bottle, see you as a source of that product. The bottle can also exist independently, Coca-Cola bottle, as a copyright. Who owns a copyright? Well, you can have individual authors, you can have joint ownership, and that joint ownership will be assumed to be 50-50 unless you, or however many owners you have, equally divided unless you contract otherwise. You know, the real questions for ownership come up in work scenario. You know, is this a work for hire? Is this an employee, or is this an independent contractor? I'm sorry.
I just wanted to relate a situation that happened to me.
Sure.
In the work for hire. I had an opportunity when I was writing my book to interview the widow of the first African-American Admiral Samuel Grable. And I just so happened to ask the student to come and videotape the interview. Well, after the interview, he refused to give me a copy or Mrs. Gravely a copy. He said that it was his work. Until today, I have left that she has not gotten a copy.
Yeah.
Is that an
Is that a work for hire? I didn't pay him anything.
You conducted the interview.
No, I conducted the interview. I asked the questions, he videotaped.
And how did he come to video the interview?
Well, because I asked him to come and do it.
Okay, since he was not working as an employee, he'd more likely be an independent contractor.
Right.
And it's really an agency question, whether someone's an employee or an independent contractor, whether the copyright will be owned by the industry or company, or as an independent contractor, the author. Oh, I'm sorry.
Yeah, could I ask that we just hold the questions to the end so we could get the overall story first?
Okay.
Would that be all right?
Yeah.
Sure. So some of those questions that are asked in terms of making this work for hire determination, you know, are how much control you have over the employer has over the work of the employee. You know, is it dictating the schedules? Are they using the employer's materials? Is the employer have some supervisory control over what the work is going to look like? How much control the employer has over the individual themselves? You know, do they decide if they can hire someone? Are they paid on a regular basis? That kind of stuff. And also, third factor is, what does the employer do? You know, if the employer is in the business of creating the type of work that the employee is producing, then that's more likely to be a work for hire situation, which the employer owns the copyright. Really, it's closer it is to a typical employee relationship, the more likely it is to be work for hire. Somebody asked for an example that these might drive home the points. For example, a newspaper article written by a staff journalist, that is likely to be a work for hire. That staff journalist writes a book. Well, did they write it on their own time? Does it have to do with the types of stories they cover? That's a little bit of an open question. If the staff journalist creates a video game, clearly that is not covered by a work for hire situation, unless they're doing it all day at work on the computer. Another question is, how long does the copyright ask? Prior to 1978, that's a very complicated question. There have been many permutations of the Copyright Act. Historical note, the very first Copyright Act of 1790 had a, you'll appreciate this, Helen, had a 14-year copyright period.
Would that be the statute of Queen Anne?
You got me there, I don't know. But today, generally speaking, it's the author's life plus 70 years for work for hire situation. It's 95 years from first publication or 120 years from creation, whichever is shorter. We were talking about this earlier before the presentation. You'll see copyright duration keeps getting longer and longer and longer. And you know, a lot of people, well, kind of well known that the Disney Mickey Mouse character was created in 1920, and you know, there's a lot of lobbying. Once every time that duration comes up, we see miraculously an extension of the copyright duration. And as Paul noted in his presentation, you know, this does distinguish copyrights from trademarks. There is theoretically an end date to copyrights, and that, as we discussed, was the intent of the founders, to provide it temporarily, and then give it back to the community for the progressive learning in the arts. Let's see. Do I need to register my copyright? As we discussed, copyright exists from the moment of creation, and registration is voluntary. But as on the slide, there are a number of evidentiary litigation benefits, important ones, to registering. Most importantly, to be able to bring suit, to get statutory damages. It's also important if you are applying your copyright to a type of product that is often counterfeited, because there are important customs benefits to having the copyright registration. Copyright notice, do you have to put the little C symbol and the year in your name? No, but again, it's highly advised. Do you have to put the all rights reserved language? What do you think? That's a good one to put out there.
It would be helpful.
You can put it. You can put it if you want, but it has no impact for a U.S. copyright, because the default on U.S. copyrights is all rights reserved. It was put in for many years because of the international treaties between the U.S. and other countries required it for you to get the full benefit of all those rights in other jurisdictions. There's no harm in putting it in, but it's not required. Also, often, you know, with the copyright notice, you'll see it's combined with trademark attributions and all sorts of other language. We will hang you, you know, all that kind of stuff. And that's really all done for deterrent purposes. But it is, you know, it is advisable for the copyright notice because, most importantly, it prevents a defendant from alleging innocent infringement, and you can get better damages. Although copyright is a strict liability offense, if it's willful, the damages go way up. Okay, so what are all these rights of a copyright owner? It's a bundle of rights. Rights to reproduce, create a derivative work, distribute copies, publicly perform, and publicly display. They all seem pretty apparent in meaning. I'll touch only on the derivative works because we talked a little bit about that before the meeting. As its title, it is a work derived or based upon a pre-existing copyrighted work. You can't go create a derivative work and then copyright the whole thing yourself. You can only go and copyright that portion of the work that you added. You must get permission from the owner of the underlying copyright in order to create that derivative work. These bundle of rights can be separated for purposes of assignment and licensing. And that's an important point, which will make more sense when we talk about Creative Commons later on in the presentation. In terms of examples of derivative works that might kind of make clear what exactly derivative work might be. Common examples: translations of books, musical arrangements, take other pieces and put them together. A motion picture version of a book would be a derivative work. Art reproductions, abridgments of pre-existing works, new editions, all those things are derivatives. Is my copyright good outside the U.S.? There's no international copyright registration like trademarks. They are geographic in nature. However, unlike trademarks, the treaties between the U.S. and a number of other countries have really been greatly simplified, particularly under the Berne Convention, that, most copyright rights, the U.S. copyright right, will be recognized in other jurisdictions. I included on the slide some helpful resources that talk about all the different treaties and what copyright laws are in place in major jurisdictions. Copyright litigation. There are some juicy damages to be had in copyright litigation, and it can have a great deterrent effect. You just need one successful case, and you really have a strong deterrent. With Napster, you saw the music industry going after individuals, and they certainly made their point. Statutory damages up to $30,000 per work. Willful infringement, $150,000 per work. And in the case of downloads, that's per download. So you can really ratchet up the multiplier pretty quickly. As we saw with the blurred lines decision, this also yields very unpredictable results. In that case, the songs were never presented back side by side. The copyright was actually in the sheet music, and that's what the jury was asked to compare. There are many people in the music industry who were very, very surprised at that decision. I didn't want to leave copyright litigation without talking about the DMCA. In 1998, Congress passed the Digital Millennium Copyright Act, and the purpose of the DMCA was to combat the potential liability of internet service providers becoming liable for users on their site illegally downloading and copying, when they were really sort of just a transition network for information. So what the DMCA does is it grants immunity to those ISPs if they can show, in fact, they are just an ISP and don't have any participation in or knowledge of the illegal activity. It does require, it puts more burden on the copyright owners to police their work. If you see something wrong, what you do is you file a takedown request, and I'm sure a number of people here may have already done so. On the website where you see the infringement occurring. Unlike a lawsuit, you don't have to have a copyright registration to make a DMCA takedown claim. ISPs are required to have designated somebody to receive those DMCA complaints and post it on their websites, and they even have to register with the Copyright Office. You'll see most smaller websites don't have this, it's just not really a part of their business. Larger websites who make a business out of user content, like YouTube, have very detailed copyright policies and very clear instructions on how their compliance with the DMCA. There are exceptions to copyright. Libraries are very familiar. Certainly, any copyright that is in the public domain is either because it is expired, it had copyright protection that's now expired, or the owner has done something to make it part of the public domain. Then those works are not subject to copyright. There are also some statutory exceptions to copyright that permit third parties to use the copyright without fear of infringement. Nonprofit libraries, nonprofit educational institutions, broadcasters. There's also an exception called the first sale doctrine that was subject to a recent Supreme Court case. That is, once I sell something with copyrighted content to you, you can do whatever you want with the original. It is yours. I've given you all my rights unless I contract it to reserve. In that work, you can do whatever you want. What you can't do is make 10 copies of it and then sell it. But perhaps the most meaningful exception to exemption to copyright is fair use doctrine. And this is where a lot of the discussion occurs, a lot of where the gray area is. The purpose of the fair use doctrine is to enable people to criticize, comment, teach, we want this stuff out in the public for these purposes. Fair use is analyzed primarily with the four-factor test, purpose and character of the use, and that's really can be very discretionary, particularly in the art industry. Really the question is it just copying the original or is it introducing something new? Second main factor is the nature of the copyrighted work. Is it fact or fiction? That's an important question. The amount and substantiality of the portion used and related to the copyrighted work as a whole. In general manner, the less you use, the less likely you will be infringing. However, there's a question on the qualitative aspect of what you're using. Is it really the heart of the work? Well, then that's a different analysis. And finally, the effect of the use upon the potential market or value for the copyrighted work. By using it, essentially, have you deprived the copyright owner of their value in the market value of their copyright? An interesting consideration here is parodies. Because parodies, that's a comment, that's a criticism, but a really effective parody can ruin your product, essentially. And as trademark and copyright lawyers, generally we find the more clever the parody, the less likely it is to be infringing. That's just how it goes. Moving on, and I hope this pace is okay. Use of third-party works. I put a big caution sign here. Because this is sort of the crux of copyright. We have all this new content online. Everybody wants to use it. Everybody wants to share it. How do we do that and not expose ourselves? So certainly anytime you use a copyrighted work, you should have permission from the owner of the work, unless one of these statutory exemptions applies. So I thought I'd go through the types of work that you might use. For this presentation, for example, we have text. Very limited graphics at my insistence because of the nature of the topic that we're talking about. But there's all this information out there. You want to use it, how do you use it? Well, we'll start with some written works. Certainly using quotes of experts and adds authenticity and value to what you're doing. You want to use it. There's no fixed amount. Generally, if you're going to go over 2 paragraphs, always attribute it. But if you're going to do more than a very little bit, you should get permission from the owner. The Copyright Clearance Center, this is what they do. They can, you search the work you want. They can put you in contact to the extent they're in their database with the owner. It's not that difficult a process. Drawings, cartoons, photographs. I mean, these are what make PowerPoints interesting, right? There's a huge collection of these online, and a number of entities who you can go to, select the work, get a license, purchase the work. As iStock, I don't know if we're totally up, but I hope I'm saying it right. And Corbett's, you can go and you purchase the images. Then it's the first sale document. You can do whatever you want with the image. That has caveats. Other sources permit licensing with attribution. Again, this is a development of Creative Commons that I'll talk about in a little bit, where you get some of the rights. You can license some of the rights. But certainly you don't want to use any image in a manner that is a source identifier. You don't want to print it all over the back of your wallpaper. You don't want to point it as being a symbol for your company. Really, it's meant to enhance the point you're making, or use as a fair use example, those types of things.